Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering college accuser PANICS as $5.3 million is awarded for false claim of assault. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from inside higher education, righting an old wrong, jury awards former Clemson student falsely accused of sexual misconduct $5.3 million on defamation and civil conspiracy claims. The case has implications for the future of Title IX. And from the Heritage Foundation, 3 colleges get their just desserts. They covered this story and 2 other stories. And from the Greenville News, Clemson student awarded $5.3 million in defamation lawsuit. The best overall rundown on this is from the Heritage Foundation. 3 colleges get their just desserts. First, Oberlin College in Ohio. Oberlin College, a hub of political correctness, lost its appeal of a $31 million judgment for defaming a local bakery and ruining its business with fabricated claims of racism. That amount includes $25 million in punitive damages and $6 million for attorney's fees. They actually had to pay even more because of interest payments, closer to $40 million. Shawnee State University, another school in Ohio, just agreed to pay $400,000 in damages to 20-year philosophy professor Nicholas Merriweather, along with his attorney fees. The school had punished Merriweather for refusing a male student's demand that the professor refer to him as a woman, using female titles and pronouns. According to the professor's lawyers at Alliance Defending Freedom, the male student became aggressive, physically encircling him, getting in his face, using expletives, and even threatening to get him fired. Merriweather offered to refer to the student under any other name he wanted instead of using pronouns, but the student and the university said it wasn't good enough and that Merriweather supposedly had created a hostile environment. Merriweather sued, saying that the university was violating his religious beliefs as a Christian under the First Amendment. In March 2021, the Sixth Circuit U.S. Court of Appeals ruled that Merriweather could sue the university, reversing a district court decision that had dismissed the case. That apparently led to a settlement by Shawnee, which includes the university agreeing that Merriweather will not be forced to use particular pronouns or titles when talking to his students. And at Clemson University, one of the most dangerous developments in recent years at college campuses has been universities setting up Star Chamber Soviet-style show trial procedures over complaints of sexual assault in which the universities deny basic and fundamental due process rights to accused students. That includes refusing to allow the students an opportunity to present exculpatory evidence that would get them out of the accusation, to question their accusers and to cross-examine witnesses, or to even be represented by a lawyer. A South Carolina jury awarded a Clemson University student, Andrew Pampu, $5.3 million for defamation and civil conspiracy by a female Clemson student, her boyfriend, and her father. The university had suspended Pampu for a year after finding him guilty of sexual misconduct against Erin Wingo. To get to that finding, however, the university ignored multiple witnesses and text messages showing that Wingo had consensual relations with Pampu and manufactured a claim only after her boyfriend, Colin Gahagan, found out about it. Pampu filed a lawsuit after he received a text message from Gahagan admitting that Pampu was innocent, that Gahagan had lied in the hearing, that Wingo wanted to have relations that night, and that Gahagan had deleted texts from that night that proved she was effing crazy. Clemson acted almost immediately to remove the disciplinary finding against Pampu and agreed to pay him $100,000, likely saving Clemson from an even bigger judgment against the university. Of course, if it had not ignored the exculpatory evidence in the first place and assumed Pampu was guilty, it would not have had to pay anything. Unfortunately, the trend towards madness at the secondary education level is sure to increase if the Biden administration has its way with Title IX. The Office of Management and Budget is currently reviewing a new rule on the 50-year-old statute that would expand Title IX's prohibition on sex discrimination to gender identity, thereby upending women's sports, bathrooms, and locker rooms in schools across the country. In addition, the new Title IX rule would roll back the Trump administration's Department of Education rule on campus assault, which requires due process protections such as representation by counsel and the right to present exculpatory evidence and cross-examine witnesses, including the accuser. This new rule once again would implement a guilty until proven innocent assumption, leading to more cases such as what happened to Pampu at Clemson. And the guilty until proven innocent model doesn't work for accusers either, or their family members, or anyone else involved in pushing a fake story. From Inside Higher Education, Righting an Old Wrong, jury awards former Clemson student falsely accused of sexual misconduct $5.3 million on defamation and civil conspiracy claims. The case has implications for the future of Title IX. Even if the Biden administration changes a rule, it won't stop defamation lawsuits. A South Carolina jury awarded a former Clemson student $5.3 million on defamation and civil conspiracy claims, the result of a 5-year legal battle stemming from unfounded charges of sexual misconduct in 2015. The lawsuit was against 3 individuals, not Clemson. Clemson already settled. But campuses across the country took note. Quote, "That's a chilling award," said Peter Lake, Charles A. Dana Chair and Director of the Center for Excellence in Higher Education Law and Policy at Clemson University College of Law. That kind of award, if it stands and isn't remitted in some way, is very impactful on college business and insurance operations. I would assume that every college in South Carolina is meeting this week to talk about the implications of this and what's going to start happening. If you get more of these verdicts, is more Title IX systems will be literally supervised by attorneys. Colleges will have teams of lawyers. The way it affects their business and insurance operations is they go and they get insurance coverage for all kinds of claims against colleges. Can they get insurance for this if they have these millions and millions of dollars worth of liability? Maybe not. And if they can get insurance, it will be very expensive. Andrew Pampu filed the lawsuit in 2017, alleging that his Clemson classmates Colin Gahagan and Aaron Wingo, as well as Wingo's father David, sought to defame, harass, abuse, and punish him following a consensual sexual encounter between him and Aaron Wingo in 2015 when they were first-year students. After the encounter, Aaron Wingo filed a Title IX complaint against Pampu, alleging she had been sexually assaulted while under the influence of alcohol. But according to Pampu's complaint, Wingo had been pursuing him and initiated the contact the night in question, which happened to be on his birthday, October 25th. Friends reported that Wingo was not intoxicated, and she remembered the encounter well enough the next morning to text Pampu and say, quote, "Don't tell Colin Gahagan, her on-again, off-again boyfriend, what happened." It was only after Gahagan found out about their hookup that Wingo claimed she had been incapacitated at the time. Gahagan reportedly told her, quote, "If you don't remember, then it's not consensual." The two began calling Pampu an assaulter to their friends. Clemson's investigation found Pampu guilty of sexual misconduct and suspended him for 1 semester. When he appealed, his suspension was extended another 12 months. While the appeal was pending, David Wingo, Aaron's father, sent a letter to Pampu's fraternity Phi Delta Theta advising the national headquarters of Pampu's alleged misconduct and pending disciplinary action in violation of the Family Educational Rights and Privacy Act. Pampu was subsequently expelled from the fraternity. Then, in January 2017, Gahagan texted Pampu, admitted he had conspired with Aaron Wingo on the false claim, and acknowledged that she had in fact pursued him romantically. Quote, "You're innocent. I lied in that hearing," he wrote. Pampu sued Clemson for violations of Title IX and the Due Process Clause of the 14th Amendment, settling with the university in 2019 for an undisclosed sum and the removal of the disciplinary citation from his transcript. The jury trial included 23 depositions from witnesses, approximately 10,000 pages of documents, and 14 discovery motions, according to Pampu's lawyer, Kimberly Lau of Warshaw Burstein. Quote, "The truth quite literally prevailed here," Lau said. "The jury sent a message that our society doesn't condone making false allegations of assault, accusing someone of criminal activity when that did not, in fact, occur, because it can be damaging. It can lead to irreparable damages. It's hard to undo." The lawyer for defendants, Aaron Wingo and David Wingo, said the case is not closed. Quote, "We are disappointed with the verdict, especially due to several decisions the judge made, excluding evidence of our defenses, including any mention of the university's Title IX investigation, administrative hearing, decision, and subsequent appeals." The attorney wrote in an email to Inside Higher Education, "We are filing post-trial motions and appeals." And so far, none of those appeals have worked out for them, because they lied and they admitted lying. Using the Title IX investigation that didn't allow evidence into the investigation can't be admitted at trial. One of the most significant motions argues that, quote, "The court committed reversible error by admitting evidence of damages resulting from the investigation, but not the investigation itself, said Jake Sapp, Chief Compliance Officer and Deputy Title IX Coordinator at Oberlin College. Quote, I think this is a pretty clear-cut example of why the procedural and substantive due process provisions of the former Education Secretary, Betsy DeVos, Title IX regulations are so important on college campuses. One of the requirements in the new regulations is that all inculpatory and exculpatory evidence has to be reviewed and at least shown, meaning evidence that tends to show the respondent's guilt but also their innocence. An allegation in this case was that all the evidence of inconsistency in Aaron's story and all the evidence of Andrew's innocence was ignored by the college. But all of the evidence that would show Andrew's guilt was accepted and relied on by the institution. For Pampu, the verdict marked the end of a long nightmare. Quote, for 7 long years, I carried a burden of accountability that was not mine to bear. He said in a statement, by the grace of God and with the support of my loving family and counsel, I was somehow able to persevere through the adversity and fight for the truth. I feel incredibly thankful for all members of the jury in Pickens, South Carolina, who chose to end this nightmare for me. I hope that the favorable verdict gives hope to many other young men who are in a position similar to mine. The future of Title IX. Though this wasn't a Title IX case per se, it stems from a Title IX investigation and has implications for the ever-evolving federal legislation barring discrimination on the basis of sex in federally funded education. Kathleen Kahn, an attorney, notes that the Pampu case started in the Obama era when the Title IX regulations were murkier, and it moved slowly because there was no statute of limitations on filing a complaint. Quote, the Obama regulations wanted to protect the victims, and they succeeded, Kahn said. But in the 2020 regulations, there are protections for the complainant, but also many protections for the respondent. During the Trump administration, after the Obama administration, they put in protections for the accuser, but also for the accused. Today's Title IX regulations would have given this young man much more protection, much more due process, more opportunity for his advisor to confront witnesses. And it also would have helped the accusers, because the accusers would not have had a $5.3 million judgment against them. Fairness is good for everybody. The 2020 regulations sparked another important change in the way campus Title IX offices are run, Sapp noted. There has been a major switch from advocate administrators to compliance administrators. Lake believes that the current Title IX regulations leave institutions vulnerable to a host of problems, including potential defamation. Quote, because by law, you have to collect narratives. You must collect all relevant evidence that includes, and very likely will include, defamatory matter. And then you have to republish that material to a decision maker and others. And then it may become the basis of other actions by an institution. So you're the clown at the dunk tank at the circus while they throw the ball, he said. It's lose, lose, lose on any table you play. And it doesn't work because colleges are not set up to do this fairly. If someone commits a crime, they should be calling the police. They should file a report. And then the police should handle it, not colleges. Of course, colleges are not set up to handle things like this. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.